I just cannot. I can't help myself. I love court. Can't help myself. It's an addiction. Can't help myself. So, um, I know you guys are glad to hear about that, but let me go right into this because this is breaking news basically. No one's broken yet. So let me do the breaking. Okay, as usual, we back in court with the appellate filings of Ari Williams. She finally filed the brief yesterday. Let's go over this brief that was filed. 18 pages. Let's see what she says in this, and then we're going to have a breakout session later on after this premiere, and we're going to talk about what's in this brief. But first, let me present it to you. Just one moment, it's loading. Okay, here we go. Let me make this just a little bigger so that it fits. Maybe 150. Okay, people of the state of Illinois versus Quadajah Johnson, appeal from the Circuit Court of Cook County. Okay, defendant's memorandum in support of Illinois Supreme Court Rule 604H appeal. Now comes the defendant, Quadajah Johnson, by her attorney Ari Williams, pursuant to the Illinois Supreme Court Rule 604H, and respectfully request that this honorable court reverse the denial of pretrial release. Defendant states the following in support of her request. Statement of facts. Number one, on December of 2024, Ms. Johnson saw a stalking no contact order against the deceased, alleging numerous threats made to Ms. Johnson herself and through Ms. Johnson family members. Number two, Ms. Johnson was pregnant with her first child throughout her active seeking of the order, having appeared at each scheduled court date. Number three, on June 18th, 2025, both Ms. Johnson and the deceased appeared via Zoom to address the issue of whether the order of protection would be granted. Number four, on July 14th, Ms. Johnson was granted a default order of protection after the deceased failed to appear in court over Zoom. Although the default judgment was entered and the deceased may not have been formally served, the deceased was aware that the order of protection was being sought against her. On September 8th, 2025, at 8:56 a.m., Ms. Johnson and witness 1, who were in a dating relationship, left witness 1's home on the 2100 South Block of State Street with their 6-month-old child after spending the weekend together. Witness number 1's black Mercedes-Benz left the alley near his home at 8:56, making a left turn onto State, a right turn onto Cermak, and parking parallel to the front of Ms. Johnson's parked black Chevy Cruze on 20 West Cermak. Ms. Johnson and witness 1 removed their child from the Mercedes-Benz and secured the child into Ms. Johnson's Chevy Cruze. Number 8, between 8:51 and 8:53, the deceased dropped off their 6-year-old in common with witness 1 at a school located across the street. Number 9, at approximately 8:57, the deceased was captured on video driving a white Kia sedan eastbound on Cermak, promptly making a U-turn on Cermak. The white Kia traveling westbound on Cermak continued toward Ms. Johnson and witness 1's parked cars. 10. The deceased double parked her Kia on Cermak behind witness 1's vehicle. Ms. Johnson's vehicle was blocked by witness 1 vehicle and deceased vehicle. At 9:02, a call was made to 911 by an unknown caller. The caller described 2 Black women hitting each other across the street on 22nd and Cermak. Though interrupted by the 911 dispatcher, the caller mentioned there's a Black lady. She seems to be an aggressor, but the woman with the green has the gun. The woman with the green was Petitioner Johnson. There was a fight that ensued between Ms. Johnson and the deceased after witness 1 moved his car. The deceased continued to rush Ms. Johnson when Ms. Johnson shot. Ms. Johnson remained on the scene after the shooting. Ms. Johnson's lawfully owned weapon was recovered from her vehicle. There were 3 spent shell casings. Ms. Johnson was detained. She has a valid concealed to carry on her. She was a valid concealed. Witness 1. Witness 1 stated to police on the scene that the deceased ran up on Ms. Johnson, told her, "I told you I was going to catch you," and swung at her. He also relayed to the police that Ms. Johnson told the deceased to leave her alone. Witness 2. Witness 2, a DoorDash driver, drove eastbound on Cermak, allegedly observing Ms. Johnson, witness 1, and the deceased on the street where Ms. Johnson and the deceased were arguing. He was unable to hear what was said by either party. Witness 2 further alleged that witness 1 was standing between Ms. Johnson and the deceased with his arms extended, that Ms. Johnson advanced toward the deceased, and witness 1 pushed Ms. Johnson away while the deceased stood with her. Witness 2 was at the coffee shop when the shooting occurred. Later at the scene, he identified Ms. Johnson as one of the women arguing. Witness 3. Witness 3 is one of the only individuals that alleged to have seen the entire incident. At 8:57, while the deceased was making a U-turn on Cermak, witness 3 was in Chinatown traveling on an eastbound bus. Her window was closest to the north side where Ms. Johnson, witness 1, and the deceased were located on Cermak. The bus window was closed. Bus footage also shows witness 3 wearing thick wireless headphones. The bus was on Cermak, approaching State Street. Bus footage captured witness 3 turning her head to the left to observe the incident between Ms. Johnson and witness 1 and the deceased. At that time, the deceased's wife's vehicle was seen on the bus footage with the driver's side door open. Witness 3 told officers she saw witness 1 pushing the deceased into the driver's side door frame and slamming the door on her. Witness 3 only observed the incident for 10 seconds before turning around and not making a threat or making a phone call. Witness 3 then got off the bus with her baby stroller and began walking eastbound on Cermak away from the incident and a few feet away from State Street. The bus stop is approximately 350 feet away from where the shooting took place. At 9:04, witness 3 called 911 to report observing a fight breaking out between a white car, a black car, 2 females. She also reported witness 1 pushing the deceased into the driver's door frame and slamming the door on her. After getting off the bus and walking away from the incident, witness 3 spun her stroller around. At 9:03 a.m., a pod camera facing northeast at the Cermak State intersection captured witness 3 crossing the east side of State Street, walking northbound, with the incident occurring on the west side of witness 3. Witness 3 was facing northbound. While witness 3 crossed State Street, she was captured on a pod camera under the CTA Green Line, where she walked far enough north behind a building to have obstructed any westbound view of the incident occurring between Ms. Johnson's deceased. Had witness 3 walked southbound towards State Street and turned right to observe the incident, the pillar for the transit authority still obstructed her view. The pod footage revealed witness 3 run from behind the building where she and other bystanders are looking to the west on Cermak. It was at 9:04 when witness 3 called 911 a second time to report a shooting. According to witness 3, after the first 911 call, the deceased entered her vehicle. She alleged that Ms. Johnson approached the deceased vehicle, making threats. Witness 3 alleged observing the deceased exit the Kia and get placed in a chokehold by witness 1. Witness 3 further observed Ms. Johnson allegedly go to her vehicle, retrieve a gun, and stand on the sidewalk. Witness 3 alleged the deceased broke free from the chokehold and took steps away from Ms. Johnson while Ms. Johnson pointed the gun at the deceased. When speaking to investigators the day after the shooting, witness 3 alleged that there was a pause after the first shot and subsequent shots. However, she told officers on the scene that the shots were successive. She also claimed that witness 1 and Ms. Johnson fist bumped after the shooting, though this was never stated to officers on the scene. It also was not until officers were on the scene that witness 3 had to remove her headphones to hear what they were saying. Witness 4, the school crossing guard was walking east on Cermak, approaching State Street. He alleged the deceased, unarmed, with a hand in the air, tried to break free from witness 1's grasp. Witness 4 turned away from the incident while the shots broke out. When he turned around, he saw Ms. Johnson with a black handgun in her right hand. Witness 4 identified Ms. Johnson as the shooter after assuming that because she had a gun, she must have fired the shots. It is alleged, according to witness 5, it is alleged that witness 5 was in her car and then watching from her workplace on Cermak when she saw the deceased and Ms. Johnson arguing on the street over witness 1. She alleged the deceased was not aggressive and that Ms. Johnson was charging at the deceased, prompting witness 1 to grab the deceased to stop the fight. Witness 5 alleged hearing Ms. Johnson state she was licensed to carry. Witness 5 claimed to hear 4 shots. Okay? Procedural facts. On December 3rd, 2025, Ms. Johnson was arrested. On December 4th, a detention hearing was held for Ms. Johnson. The court ordered her detained. A motion for relief pursuant to Supreme Court Rule 604H was filed on December 22nd, 2025. An amended motion of relief was filed on January 7th, 2026. On January 8th, the Honorable Judge Michael Clancy denied Ms. Johnson's amended motion for relief. That same day, Ms. Johnson a notice of appeal from the pre-trial detention order. Argument. This court should reverse trial court's order to detain Ms. Johnson. This court should reverse the trial court's decision to keep Ms. Johnson detained because the state failed to prove its burden by clear and convincing evidence. The issue presented to the trial court's detention decision is subject to this court's independent de novo review. People versus Morgan. The trial court's ruling to keep Ms. Johnson detained during her trial amounts to the reversible error where the state has failed to prove by clear and convincing evidence that 1, the proof is evident and presumption great that Ms. Johnson committed the offense of first-degree murder. 2, Ms. Johnson poses a real and present threat to the safety of a person, persons, or the community. 3, there are no conditions or combination of conditions that can mitigate the real and present threat posed. A, the state failed to prove by clear and convincing evidence that the proof is evident and presumption great that Ms. Johnson committed the offense of first-degree murder. In the state of Illinois, monetary bail has been abolished. All persons charged with criminal offense shall be eligible for pretrial release before a conviction. The court must hold a hearing and make required findings. At all pretrial hearings, the state bears the burden to prove by clear and convincing evidence that any condition of release is necessary. A court may order a defendant detained pending a trial if the defendant is charged with enumerated detainable felony offense found of the act. If the defendant poses a real and present threat to safety of any person or persons of the community. Roe versus Raul, 725 ILCS. When pretrial release should be denied to a defendant on the grounds that they pose a real and present threat, the state has the burden of proving that the claim based in a specific articulable facts of a case. Here, the state failed to prove by clear and convincing evidence that the proof is evident and presumption great that Ms. Johnson committed the offense of first-degree murder. In Illinois, a person is justified in the use of force against another when and to the extent necessary that they believe that such conduct is necessary to defend themselves against another or against others' imminent use of unlawful force. On September 8th, 2025, Ms. Johnson was justified in her use of force against the deceased who was looking to incite violence against her. Ms. Johnson, accompanied by her boyfriend, witness 1, and their 6-month-old child, were going on with their day after spending the entire weekend together. It was the deceased who approached Ms. Johnson and witness 1 on 20 West Cermak and blocked Ms. Johnson's vehicle with her white Kia after completing a U-turn. The deceased dropped her and witness 1's 6-year-old son off at the school across the street prior to approaching Ms. Johnson. The deceased was initially driving eastbound on Cermak and ended up with her vehicle parked westbound on Cermak across the street from her child's school. Although this encounter was the first time Ms. Johnson and the deceased saw each other in person, the deceased had continuously threatened and harassed Ms. Johnson. Among those threats, the deceased found Ms. Johnson's grandmother's phone number to mention her desire to kill Ms. Johnson. When Ms. Johnson petitioned for the stalking no contact order against the deceased, she was fearful for her life and fearful of the individual, reasonably believing the deceased would follow through on threats she made to end her life. Similarly, on September the 8th, 2025, Ms. Johnson once again reasonably believed the deceased would inflict imminent death or great bodily harm against her. The deceased willingly and uninvitedly approached Ms. Johnson in an aggressive manner, blocked Ms. Johnson's car in, and made it physically impossible for Ms. Johnson to leave the area. And the deceased physically attacked Ms. Johnson. Witness 1 stated to the police on the scene that the deceased ran up on Ms. Johnson and swung at her. Ms. Johnson was absolutely attacked by the deceased. It is also exhibited by her appearance before and after the incident, where video footage prior to the incident showed Ms. Johnson with tidy hair, Miss Johnson's hair was completely disheveled once police arrived on the scene. Miss Johnson being physically attacked by the deceased is also corroborated by the 911 call made at 9:02 from the unknown caller who was at the scene September 8th. The unknown witness reported to 911, 22nd and State, across the street from the school. There are two black women fighting. The witness confirmed the two women were hitting each other. She continued with, there's a black lady. She seems to be the aggressor. Then she goes on to talk about the one with the gun who has green on. Rather than stating that the woman with the green, Miss Johnson, was the aggressor, the witness separated Miss Johnson as simply being the one with the gun, wearing a green two-piece tracksuit. The witness illustrated the black lady who seemed to be the aggressor as the deceased who had dark skin. These numerous accounts undoubtedly prove that Ms. Johnson was physically attacked by the deceased, directly contradicting the inconsistent, unverifiable observations from witnesses 2, 3, 4, and 5. Witness 2, for instance, did not observe the actual shooting since he was inside a coffee shop within the vicinity. Witness 3 cannot be deemed credible where there are various inconsistencies in her statement. On the scene, witness 3 recounted there were 5 shots in succession, while the next day she told officers there was a pause after the first shot. While traveling eastbound on the bus, she observed the incident between all 3 parties for only 10 seconds and did not call 911 until she exited the bus. She claimed to hear Ms. Johnson threaten the deceased while traveling on the bus since the bus's window was open. However, not only was the window closed, but witness 3 also wore thick wireless headphones on her head. She had to remove those headphones when speaking to police on the scene, suggesting impaired hearing with the headphones on. Once off the bus, witness 3 walked eastbound away from the incident. She proceeded to cross the busy street of Cermak, walking and facing northbound at the time the incident took place. Witness 3 view of the shooting was also obstructed by CTA Green Line building, where she was captured on pod camera, emerging from behind the building only after bystanders noticed the incident, which occurred approximately 350 feet away from them. Witness 4 did not observe the actual shooting since he was facing away from the incident, turning around only to see Miss Johnson with a black handgun in her right hand. Similarly, witness 5 is not credible, where she allegedly watched the incident from inside the lobby of her workplace on Cermak. Her view would have been absolutely obstructed, not only from the distance between the incident and her workplace, but also from any parked cars and trees on Cermak. Thus, the accounts relied on by the state to conclude that Ms. Johnson committed the offense in which she was charged were heavily unverifiable, speculative, and not credible. Ms. Johnson's use of force was reasonable, and the mere fact that multiple shots fired does not negate the claim of self-defense. Further, previous courts have determined first-degree murder charges are insufficient to sustain a pretrial detention. As much, the state failed to prove by clear and convincing evidence that Ms. Johnson committed the offense of first-degree murder. The state failed to prove by clear and convincing evidence that Ms. Johnson poses a real and present threat to the safety of a person, persons, or the community. The state failed to prove by clear and convincing evidence that Ms. was a real and present threat to the safety of a person or persons in a community. A court may consider factors articulated in 725 ILCS, in addition to the specific articulable facts of the case, when determining whether a defendant poses a real and present threat to the safety of any person. Ms. Johnson is a 31-year-old pregnant woman and current mother of 1. She has lived a very law-abiding life. Ms. Johnson ran a successful and lucrative lash business and earned acceptance into school to become a dental assistant. Besides misdemeanor convictions, one of which was a traffic conviction stemming from over 10 years ago, Ms. Johnson has not been arrested, charged, or convicted of any violent crimes. Ms. Johnson is not a person of violent character. In fact, Ms. Johnson has been readily compliant with law enforcement and the subsequent investigation into this case since the incident took place. While on the scene, Ms. Johnson did not flee or evade arrest or prosecution. Most notably, Ms. Johnson spent approximately 87 days outside of custody from September 8th until she was arrested and charged on December 3rd. During these 87 days, Ms. Johnson did not reoffend, nor did she attempt to leave the state of Illinois. The record is completely devoid of evidence illustrating Ms. Johnson poses a real and present danger, or that she will fail to comply with any court-imposed orders of conditions. Further, a finding of dangerousness alone does not automatically warrant detention. Subsequently, the fact that a person is charged with a detainable offense is not enough to warrant detention, nor is it enough that the defendant poses a threat to public safety. In believing that Ms. Johnson was emboldened by her CCL, the state completely overlooked the threat and great bodily harm that the deceased imposed on Ms. Johnson on September 8, 2025. The fact that the deceased was unarmed does not negate the incredible and imminent danger she imposed on Ms. Johnson, nor does this fact negate that the deceased was indeed the aggressor on September 8, 2025. In fact, under Illinois law, where it is clear that the aggressor is capable of inflicting serious bodily harm on the defendant without the use of a deadly weapon, it appears he intends to do so when it is not necessary that the aggressor be armed for the defendant to employ deadly force in self-defense. Here the deceased went to her car but came back to attack Ms. Johnson, leading Ms. Johnson to believe that the deceased was coming back to cause great bodily harm based on the previous threats made to kill her. Essentially, it is exceedingly clear that Ms. Johnson is not a threat to the safety of persons or community, and the state failed to prove by clear and convincing evidence that Ms. Johnson poses such an alleged threat. This court should reverse the trial court's order of detention. C. The state failed to prove by clear and convincing evidence that there is no condition or combination of conditions that can mitigate the real and present threat posed. The state bears the burden of proving by clear and convincing evidence that no condition or combination of conditions can mitigate the real and present threat to the safety of any person or persons in a community based on the specific articulable facts of the case. There are various factors a court shall consider when determining which conditions of pretrial release, if any, will reasonably ensure the appearance of defendant as required, the safety of any other person in the community, and the likelihood of compliance by the defendant with all the conditions of pretrial release. The conditions of release imposed shall be least restrictive conditions. In the present case, the state relied on the offense to disregard any consideration of least restrictive means outside of detention, only going to the extent of stating that there are no conditions or set of conditions that this court can pose that will mitigate the risk this defendant will pose to individuals in a community as well, especially given the specific facts of this case. The trial court itself also refused to impose electronic home monitoring based on the nature of the offense where multiple shots are fired. And because Electronic home monitoring cannot respond in real time to protect someone who is reacting to a volatile situation. Importantly, the nature and circumstances of the charged offenses is just one factor to consider in determining whether the threat posed can be mitigated by conditions of release. The court in Atterbury also made clear that one relevant consideration is whether there is reason to believe that the defendant is likely to violate the conditions the court might impose. However, a court should not rule out pretrial release for the defendant based on a general perception that conditions of release are loosely monitored. The trial court here, similar to the court in People versus Mayha, disregarded all the evidence showing that Ms. Johnson would comply with orders setting conditions on her release and ordered the defendant detention based solely on the bare allegations and underlying the instant complaint. The court in Mayha reversed and remanded for a new hearing regarding the defendant's conditions for release. Even then, other alternatives to detention enumerated with the pretrial fairness were not considered, such as refraining from possessing a firearm, refraining from going to a certain geographic location, being placed under direct supervision of the pretrial service agency, etc. Consideration of Ms. Johnson's age, prior employment, lack of criminal history, lawful gun possession, family life, and a lack of violent behaviors are relevant in determining whether imposing conditions of pretrial release will actually help mitigate any alleged posed threat, and such criteria should have been meaningfully considered in the case at hand. Conclusion: the state has failed to prove its burden by clear and convincing evidence to keep Ms. Johnson detained, and this court should reverse the trial's court order to keep Ms. Johnson's detained pending trial. Wherefore, defendant appellant Quadajah Johnson respectfully requests this honorable court vacate the trial court's order for pre-trial detention. And so I doubt it. I doubt it. And she had to sum in 4,500 words, as you can see here. Fewer than 4,500 words. And so none of that changes anything. Anything. And it really shows the holes in Quadajah's story and Carlos' story. Why are all the witnesses 2, 3, 4, and 5 on one accord, and the only people saying anything different is Carlos and Quadajah? She shot Romeca in cold blood, not once, not twice, but she would have shot her 3 times or more if the gun didn't jam. She shot her on a crowded street at 9 o'clock with everybody out going to school. Somehow, they don't think that she a danger to society. We'll talk about it. But first, I wanted to just read the filing. Read the brief so you know what she going in there working with, you guys. So we're going to chop it up, like I said, on a later stream at lunchtime. We're going to get together and talk about this, or later on this evening. Let me know in the comments what time y'all want to discuss. But this is what went out yesterday, and it don't look no better than what we've been looking at, okay? So we're going to discuss this. You guys let me know what you think. And as always, I'm going to keep dropping receipts.